This show is sponsored in part by St. Germain Catering, a woman-owned business that is professional in every delicious detail. And Fairfax Social Sports, Northern Virginia's largest co-ed men's and women's adult sports league, with over 32,000 players who participate in flag football, softball, basketball, and other adult sports. And finally, the Ruddy Law Firm in Fairfax City, Virginia, a law firm that provides legal services in the fields of business, probate, estate planning, and elder law. Welcome to the Probate Nation. My name is Richard Ruddy, and I will be your host this evening. In earlier shows, we have discussed the probate journey that many will need to embark on in order to settle the estate and transfer the assets of a loved one who has passed away. Once you visit the probate office and get officially qualified to drive the probate train, there are many tasks you need to undertake in the course of this journey. In today's show, we will discuss the initial 3 documents you need to prepare as executor. 1 you need to mail to the beneficiaries, 1 you need to file with the probate office, and 1 you need to file with the Commissioner of Accounts. All of these need to be done in a timely manner. Failure to properly complete and file these forms can cause your probate train to come to a stop. And if not done properly and approved, in the case of the inventory that's being filed with the Commissioner, you could face legal efforts in court by the Commissioner to have your authority to drive the probate train revoked. That is not something we want to see happen, if at all possible. So all of you newly qualified executors and administrators, please get your pencil and paper ready to take notes as we have a working session with our guests on the following 3 documents. First, the notice regarding estate you must give to beneficiaries and heirs of the estate. Second, the affidavit of notice regarding estate you must file with the probate office confirming you have given the proper notice to the beneficiaries. And finally, the inventory for decedent's estate that you must file with the Commissioner of Accounts. With me today is a prominent Northern Virginia attorney in private practice who specializes in estate, trust, probate, and guardianship matters. He also currently serves as the president of the Arlington County Bar Association. Please join me in welcoming Attorney George Dodge. George, welcome.
Thank you, Richard.
You know, the probate journey begins with the probate office, when the probate office issues a certificate of qualification to someone, which then empowers them with the duties and responsibilities of executor or administrator. At the time of qualification, the probate clerk normally gives them an envelope filled with a bunch of forms and some instructions. What we'd like to do today is actually walk through some of those forms that these folks need to have to take care of to send to beneficiaries and otherwise file with the probate office. So let's take a look at the first form, which is the one called Notice Regarding Estate. On the screen, our viewers will see this official Supreme Court form, which is 2 pages long, and we have added numbers on the form for reference during the course of our discussion with George today. So upon qualification as an administrator or an executor, what is the purpose of sending this notice, George?
Well, this is an official document that needs to be sent to each heir, whether they are an heir at law or a beneficiary pursuant to the last will and testament of the decedent. And this is the official opening of the estate, and it's required under the Code of Virginia and has been since 1993. And it's to put all parties of interest on notice that an estate has been opened, the location of the estate, and it's an advisory to some extent of their rights as beneficiaries or heirs as well.
Very good. So let's take a look at the actual notice form, and let's kind of walk through all the information that's needed to complete that notice, and we can understand where it can be found. So let's take a look at, for instance, number 1. What is this?
Well, upon qualification at the probate office, the clerk will issue a number, which is the estate designation, and that would be in number 1. Of course, number 2 would be the decedent's full name, and then you also need to list the date of death. You will have to bring a certified copy of the death certificate to your appointment, so these are matters you can get from that document. The notice is also important in that the next few lines indicate what circuit court is this probate designated. Sometimes with people own property in several different states, several different counties, there might be a question of where the estate might be open, but this is clear evidence to a beneficiary or party what the locality is, and it includes on number 5, their mailing address.
And let me stop you for a second. So if someone didn't know where to find that, where would they go find that information after they've been qualified?
If you're a beneficiary,
If you're the administrator or the executor, you need to fill out this form, and you want to know what county I should put down as far as where the probate's taking place. Where would they find that information in the information they've received so far from the probate office?
well, as you mentioned a moment ago, you're handed a probate packet of information, but what governs, and I hope this answers your question, Richard, what governs the site for the probate is the domicile or residency of the decedent. And sometimes there can be some debate over that, especially if there's land owned in different places, but that's going to determine the circuit court you file in as the person's domicile. Might not be where he was or she was at the time of death, but it's where they were domiciled.
So for purposes of folks that come home and they're 2 weeks after they've been qualified, if they go back and look at their certificate of qualification, that would show the county where they got qualified or the city, and then they would put that on that particular spot. That would tell them.
The file number is on the certificate of qualification, otherwise known as a letter of qualification. The estate, the name, all that would be on your certificate that the clerk issues upon you qualifying.
Okay, so let's take a look at number 6 on this notice form. Tell us a little bit about that information.
Each beneficiary or heir at law it should receive one of these forms. I think that one of the first things an administrator or executive needs to do is identify each heir, if there is no will, secure their address, and place it on these notice forms, and make sure that they're accurate, and so that these persons really have effective notice of the estate being opened. So that is for the beneficiary or heir to have their information on number 6.
Okay, and then you're working down number 7. That would be where we would put the name and address of the administrator or executor. And then how about the rest of the form? Anything else you want to comment about?
Well, going back to 7, you might even want to put your email address on there, as so many more people communicate that way. But
good suggestion.
I think you need to send a hard copy to everyone with a firm mailing address, but also provide them other means to reach you. Then number 8 below that is where you identify in what capacity are you sending this document out. So you can see it lists personal representative, proponent of the will, or a person having an interest in the estate. The latter being perhaps it's a creditor who's qualified in order to have their claim satisfied.
So the most challenging part of this form really is, as we talked about, is figuring out who are the heirs at law. Okay, because if you have a will, the will give you people who are supposed to receive, and you can generally track down that information. But the heirs at law would be something that would be determined by the Code of Virginia, and we'd have to work through that statute, and that'd be a place in where the administrator or executors might need the assistance of an attorney to help them figure that out. How much time does an administrator or executor need to spend in actually locating a missing heir?
It's not so much an element of time, it's diligent effort.
Okay.
And in some situations, the family or everyone knows who the heirs are or who the beneficiaries are. It gets a little more difficult when you might have a non-family member or a distant cousin who qualifies. And I think the best advice to provide that person is keep a record of how you map out the family chart pursuant to the course of descent and distribution that Virginia recognizes, and then network among family members to ascertain whether or not some persons have passed away, and if they have, and they were a beneficiary, do they have children? Because they could be beneficiaries as well, depending upon the terms of a will.
So what's the time period in which the notice has to be sent out?
You want to send the notice out within the first 30 days of qualification.
Okay. So the next form, after the notice has been sent off to the beneficiaries, the next thing we have to do is we actually have to file a form with the probate office, letting them know that that notice has been given. We have to tell them who we gave the notice to, and there's a specific form to allow that to occur, which is called an Affidavit of Notice, which is appearing on our screen as well. And this is also a Virginia Supreme Court form. It's a fillable PDF form which you can download from the Virginia Supreme Court. The form on our screen has been numbered, so again we could ask a few questions and George could help walk through some of the more important things. And so briefly, George, let's kind of walk through this particular form. What's the purpose behind the form?
This is a document which certifies to the court that the administrator or executor has made an attempt, whether successful or not, to locate and send notice to all the heirs or beneficiaries.
Okay. And let's just kind of look at the form now itself. And so it looks like in the numbered areas, number 1, 2, and 3 are all information that would have been gathered at the time that you prepared the notice to beneficiaries. That's pretty easy to report. And so, and then of course, if you've actually given notice to people, you have that information. There's a spot on the form at number 7, 8, and 9 to record that information. But let's talk about number 10 and number 11. Talk about number 10 for a second. You know, what is the purpose behind this particular section of the affidavit?
Again, we live in such a fast-moving world, and sometimes people have moved, they've relocated, and it puts the burden on the administrator or executor to make a reasonable effort to locate them. And if they don't know them, no one in the family knows their whereabouts, you can look on the internet, you might develop some search engines to use, and if you've identified persons but can't find them and you've used whatever resources that you can think of, you might want to consider hiring a private investigator to locate that person. And if you're in a situation where there's no surviving spouse, children, brothers or sisters or parents, you're looking at cousins as beneficiaries, and there you could have 20 to 50 or 60 cousins, and if you, at that stage, you might want to consider hiring what's known as an heir locator company or firm to make sure you've had a proper methodology to find all those persons.
Okay. Well, that's good. Now, so in the case of number 10 and 11 on the affidavit form, to the extent we either know who they are but don't have their address, or know they exist but don't know their name and can't find them, that's where we would actually let the court know that that's what we have found after our due diligence. So once we have the form completed, the affidavit needs to be filed within 30 days. Is that correct?
With the probate office and with a filing fee.
Okay. Finally, in your experience, you know, what are the most common mistakes executors and administrators make in preparing and sending the notice and the affidavit? Briefly, if you could share with us.
Often, persons don't realize that in addition to the notice going to the beneficiaries, if there's a will filed, that state law requires that the heirs receive it as well. So frequently the heirs are omitted if they are not the same heirs that are beneficiaries. So make sure you include all list of heirs,
okay.
All heirs that are on the list. Also, you want to make sure that if there's what's called a last will and testament that has a pour-over provision that transfers funds to an existing trust agreement, you want to make sure that you give notice to the trustee as well. That's frequently omitted, and if you are that person, the trustee is the same as the executor, just acknowledge that you are the trustee and that you've therefore no notice of this estate being open, but include the trustee if there is one, and it is a pour-over will.
George, thank you for taking the time with our viewers to discuss the notice regarding estate requirement and how to properly prepare it, as well as the affidavit of notice regarding estate, which needs to be prepared and filed with the probate office to confirm that proper notice has been given to the heirs and the beneficiaries. This information and your suggestions will help newly appointed executors and administrators get their probate started correctly. We're going to take a short break to catch our breath and let the probate train move down the track a bit, and then return with our next guest to discuss the inventory form that must be filed with the Commissioner of Accounts within 4 months of when you are qualified. Our next topic is the inventory that must be prepared and filed with the Commissioner of Accounts. This is the initial filing with the Commissioner, and it is important to do it correctly. With us today is a Northern Virginia attorney with extensive experience in preparation of this probate filing. He worked as an auditor and law clerk for the Fairfax Commissioner of Accounts Office for several years and has audited hundreds of inventory filings to the Commissioner. Recently, he entered private law practice with his spouse, Jennifer, forming the law firm partnership of Tomac and Tomac, PLLC, in Loudoun County, Virginia, which focuses on probate, estate planning, and representing both fiduciaries and beneficiaries throughout the estate and trust administration process. Please join me in welcoming Attorney Jared Tomac. Welcome, Jared.
Thanks, Richard.
Good to see you.
You too.
On the screen, our viewers will see the official form called the Inventory for Decedent's Estate, which is about 5 pages long. There are instructions to complete this form, but we will not be showing these on the screen. We've added numbers on the form to aid our viewers in following along as we have a discussion about the inventory with our guest. Jared, let's work through the inventory form for our viewers. What exactly is the purpose behind the inventory?
Well, the inventory is really the baseline that starts the Commissioner of Accounts process of accounting for the decedent's estate. It's kind of the snapshot of what the decedent owned on the day they passed away.
Okay. And so on the inventory form, we're going to list the assets that the fiduciary must account for. Is that right?
Correct. Anything listed on the inventory is going to be carried forward onto an account, and the fiduciary is going to have to file those accounts and report what he's done with those assets. This is really the starting point that gets the ball rolling.
So as we look at the page 1 of the inventory, which is on our screen now, let's take a look at this and take a look at the top of the form and tell us what's going on up there.
Sure. The top part of the page is really the information material for the commissioner or for anyone reviewing the inventory for that matter. Number 1 on the inventory is the court file number. You also hear this as the fiduciary number or the matter number. This is the number that gets assigned to the probate office, and this carries forward throughout the administration process. Fiduciaries should include this number on any filing that they use or any correspondence with the Commissioner's office. Number 2 is the jurisdiction where the fiduciary qualified, whether it be Loudoun or Fairfax or Arlington. And number 3 is the decedent's name. Number 4 is the fiduciary's name. And number 5 is the fiduciary's date of qualification. And if they don't remember that, they can look on their certificate of qualification. And number 6 is the day the decedent passed away.
Okay, so it seems fairly straightforward, but we get to number 7 on the inventory, and there's a bunch of boxes to check off. What do we do there?
Sure. Most fiduciaries are going to check, of the first 3 options, the first inventory. This is the filing that starts the process. If a fiduciary has realized that they've put the improper information on, or if they need to report that there are assets discovered after they filed an inventory, that's where the second 2 boxes come in.
Okay. And then there's another set of boxes to check as well. Talk about that, would you please?
Sure. This is where the fiduciary is telling anyone reviewing the inventory the authority under which they're acting. Either they're an executor or administrator or a curator. And really, most people are not going to be a curator. Most people are going to be either an administrator or an executor. Simply put, an administrator administers an intestate estate where there is no will, and an executor administers an estate where there is a will.
And if someone was not sure about what capacity they qualified, again, they can look back at their certificate of qualification, and that information would be on that form.
Absolutely.
Okay. Okay, so what appears, so that appears to cover the identification information. So let's take a look and get into the substantive stuff. Just talk about globally what is captured on this inventory form.
Sure. There's really 5 parts, and somebody can look through the form and see that there's 5 different parts. And the first is the decedent's personal estate, things owned individually by the decedent. The second section is part 2, and this is the decedent's interest in multi-party accounts, joint accounts. Number 3 is the decedent's interest in real property over which the fiduciary has a power of sale, and we'll get into what that means. Number 4 is the decedent's interest in other real property in Virginia where they don't have a power of sale. And number 5 is the decedent's property outside the Commonwealth.
Okay, so let's go back and let's get into some of the detail. Let's start on page 1, which number 10. Let's talk about the tangible personal property and his personal estate. Kind of
Sure.
go through what that's about and what goes on that section.
This is where the majority of a decedent's assets are likely going to be listed. These are things that are owned individually by the decedent, and it's almost everything. It's going to be bank accounts, brokerage accounts, tangible personal property. It's going to be those odd interests in a partnership or an LLC. These are things that the decedent owned individually without anybody else. Part 2, well,
So we're still on page on number 10. So when we get to bank accounts, tell me how we should actually record a bank account or
Sure.
a brokerage account in section 10 of the form
Sure.
we're looking at in part
So when
1.
you're actually listing the asset down, for a bank account, you're going to want to tell the reader where the financial institution is. So we'll put down, for instance, PNC Bank. You're going to want to tell them what type of account it is, whether it's a savings account, a checking account, money market. You're also going to want to identify that specific account, so we need to put the last 4 digits of the account number. Don't put all of them, only the last 4 for security purposes. And then you put the value of that asset on the day the decedent passed away. Relatively simple for a bank account. For a brokerage account, which also goes in part 1, that's an account where somebody owns multiple types of assets or stocks. So you're going to want to list where the brokerage account is so the auditor can look at a statement, but then you need to itemize each of the securities within that brokerage account. So you're going to want to put down the name of the stock or security, the number of shares held by the decedent on their date of death, and the value of those shares. I also like to include the ticker symbol so that the auditor can quickly look up and verify the amounts.
So in case of brokerage accounts, if I have a brokerage statement that lists all that on there, can I simply record that and refer to that attachment rather than trying to go into and detail all that?
You absolutely can.
Okay.
Many financial institutions will give you what's called a date of death valuation if you ask them and say, because your statement's going to record the end of the month. And the inventory should truly be the date of death, so you can ask Prudential for a date of death valuation from February 14th, and they'll list the values of all those assets and what was in the decedent's account at that time.
Okay, very good. How about, also, again, we're in part 1, which is we've identified as number 10. What about all the household furnishing?
It can be a little difficult for somebody to value what somebody's wardrobe was worth. So what the legislature's allowed people to do on the inventory is to use a category and say household furnishings or the decedent's household possessions. Those can be done in a category as long as any single asset isn't worth more than $500.
Okay.
By way of example, jewelry comes up often. A decedent has owned several pieces of jewelry, but let's say only the engagement ring is really worth more than $500. Then you're going to have 2 entries. You're going to have an engagement ring valued at $2,000, and then you can have other jewelry valued at whatever that amount might be it $2,000 or more.
Okay. Let's turn to page 2, which is part 2, which we've identified as number 11 on our form. So briefly, talk about what goes in these multi-party accounts. Because I know there's some distinction between what does go and what doesn't go.
Sure. Multi-party accounts are listed not because they become part of the probate estate, but they're listed there for creditor purposes and for informational purposes. So these are not going to get carried forward and accounted for, but what needs to be reported there is a interest in a multi-party account at a bank or a credit union. And these are accounts where the decedent owned it jointly with someone else, where they have a POD designation or where they have a TOD or a taught and trusted designation, and they pass to somebody else outside of probate, but the creditors have a right to know that those assets are there.
So it's for information purposes.
Absolutely.
Okay, so Part 3, 4, and 5 all capture the real estate. So Part 5, just very briefly, is for report real estate located in another state.
Correct.
So Part 3 and 4 are really your Virginia real estate. Tell us what goes in those two and why.
Sure. Part 3 deals with property over which the fiduciary has a power of sale. If the fiduciary is an executor and they're operating under a will, the will might give them that power of sale, or it might not. It could direct them to sell, or it could just give them the authority. And it can do that expressly, or it can do that through a reference to a code section. Any time that a fiduciary has that power of sale over real property, then it goes in Part 3. If they don't, it goes in Part 4.
Okay. So we've completed the form as best we can with due diligence. We sign it. The fillable form that is available from the Supreme Court, actually when you add all your numbers up, it will automatically total stuff so that we can actually see what goes in number 8 and 9 on page 1. And so we sign the form and we send it off to the commissioner. Do I need to provide any supporting documentation for anything I'm saying on that form?
Not at this point. With the inventory, you're only going to provide the inventory and the certification that it's accurate. The supporting documentation will come later on down the road when the fiduciary files their account.
Okay. Given your experience of auditing inventories, and we can capture quickly, what are the most common mistakes that you encounter that fiduciaries make when they do an inventory?
Sure. A very common problem is not including an account number, not properly itemizing items in a brokerage account, or including too much of an account number. We're going to have to redact some of that if those are filed.
Very good. So the inventory must be filed within 4 months of when someone qualifies. And of course, if they run into a problem, they can call or can write and get a short extension from most of the commissioners. Is that correct?
That is correct.
Okay. Jared, I want to thank you for this valuable tutorial on how to prepare the inventory. Your clear and detailed explanations will certainly help executors and administrators properly complete this time-sensitive document. Again, for our viewers, the Virginia Supreme Court PDF fillable forms can be located on the Virginia Supreme Court website, and that URL is on your screen. You can also find them on the Probate Nation website at www.probatenation.com. We've covered a lot of material this evening, all critically important to keep your probate train on track and moving forward. With these filings, the notice, the notice to the beneficiaries, the affidavit of notice to the probate office, and the filing of the inventory with the Commissioner of Accounts, your probate train can now continue on its way. At this point, you have left the probate office and are now under the oversight of the local Commissioner of Accounts, who you will be reporting to on your progress with the many tasks you now must undertake to administer this probate. Future shows will get into the details of the most common task and the purpose of why each must or should be done, so that you can remain in good standing with the Commissioner during the course of your probate journey. On behalf of myself and the entire Probate Nation, thank you for visiting with us.